interpose interpretation in the Mandinka language. I am looking at the boot. I think the Mandinka interpreters are already in place. So as you speak, you make short sentences and allow the interpreters to interpret what you say. Thank you.
Thank you very much. So I will just read the introduction of our paper, then I will highlight my own personal experience and the experience of other judicial officers during their time at the judiciary.
Akabe folola damen wolem abe kacha daire la diamu kamulu menula aba folola woleto na bota woto bitun asina tenten kafuta kolu ma men ya lonko wolleketa ate fango kolu menu je ay kolu menu taki adunta kolu menu kono asiwolu fanalu kacha anin akafunyo doku nyo kotengulu fanali kolu menu dolu taki asina dungulu fanalu kono ke kacha.
The systematic human rights violations in the Gambia from 1994 to January 2017.
Kabo 1994 sangola tajire yal nin tilimbali yal menu tamata banko kan sartolu lo nyala karola banko kan jang kata han for 2017 sankono.
Did not spare the judiciary of the Gambia.
Amang jenke banko la kiti bunda nyim fangoy freng.
Judges and magistrates were frequently and unconstitutionally removed from office without adherence to constitutional procedure.
Jojol ni magistrate wollem kiti ndirlalu ni kiti kuntulalu wati ni wati be ike bondi la officer tole ke bondi do ko la abukana ke dalila ko kan sartata kan fereta kan adunga nin tilingu manta nyola wonyon jamal leketa ite la wuce wato nyinna.
Executive branch of government been dissatisfied with judicial pronouncements been made in court, often resulted in filing bogus and frivolous charges against judges and magistrates.
In kito luketa hanfo kito lutata ye kuntu nyamema niwo mandia officer ye me ya lonko banko kunton kola officer le moti isa lonko ibe kuma soto balo le fewja la ke la nyo kan nakari kumolu fo men ya lonko ibe le tilina wo jojol wala o kitindirlalla pour nyin kamala ke nambara do koto itelie do ku senu menke wairi amandia nyaton konyiye.
In order to humiliate, intimidate, persecute them for their decisions.
Andu ka kenyele kan ke malundi ke detendi ke kijota ila do ku kendo kan be men tamandi kan ye kitolu kun nyami.
Justice Jaiteh, you said this was done frequently by the executive branch.
Justice Jaiteh ko nying mukula me alanko akakelo nunga dalina kula me alanko akake anu akabo men la karola wala executive wala santon koldi.
Who are you referring to specifically?
Niko santon kol executive ibe jumale fama.
That is the head of state
and
the Ministry of Justice and the other ministries. That is the president and the cabinet, the ministries.
Walem akabo president le la karola aning minister bunda kotangol walem cabinet menu marta banko sambanya kunyalula akabo le la karola.
And by president you referring to Yaya Jammeh for the 22-year period in which he was head of state.
Munda nigo president walem ibe Yaya Jammeh la wato men na munu banko nyaron koti ni banko kanjang sanji muang animfula.
That is correct.
Walem tonyati.
Proceed.
It is worthy to emphasize that the 1997 Constitution of the Republic of the Gambia
nyata puruka foko 1997 banko sambaran sartu buko men yadada ikafo meye 1997 constitution o nying
provide for the clear separation of powers
andu way nyine itandi ka fengolu bo nyokan ke fata men keta sembo la nyati
guarantees the independence of the judiciary.
Me yalon ko wala nyanta kiti bunda nyi londi la afaye ke kangolondi
section 120 subsection 3
wala keta bunda keme anin sabanjango la fanna sabanjango nyinti no constitution auto.
It provides that
me yanyi itandiko
in the exercise of their judicial functions
ruke la doko tamandi luwa nin tilimu doko la karola
the courts
iti bundalu
the judges
itindirlalu
and other holders of judicial office
animo kotanglu men ya lonko palaso lu bebulo kiti do ku bundala
shall be subject only to this constitution
wolu la do ko be ko kundinkela abelala constitutional sarto lekan
and the law
ani loi
save as provided in the chapters of the Constitution,
ya sartolu landi nyamin na banko la constitutional law dinkira luto
shall not
ando atakela nyintiko
subject to control and direction of any person.
te tarla mo womondi na ya maro ni kango kang me ya lonko iteli nyanta tamara wo ya maro ni wo mari wolu lawo kangle kang.
Section 120, subsection 4 of the said Constitution
constitutional la bunda keme bunda muang njango nyin na fanana ni njango atenyin constitution kilin kono
provides that the government and all departments,
we nyine itandi ko man sakunda doku bunda lube
agencies
ning ila denna doku bunda ko tengolu
of the government
men bebe man sakunda karola
shall accord such assistance
ul be nyanta o ma koyro tamandila kadi
to the courts
iti bundala
as the courts may reasonably require to protect their independence,
wakati okiti bundalu fanalu nyimunyanto leti pur ila taram fambulo yo kanta aesa
dignity,
ila bunya
and effectiveness.
ning ila doko la saha.
Section 141,
Bunda keme bunda tanani ning kilinjango
paragraph 4 to 9
wala sapaka damu tanani njango kata hanfo konon to njango kang
of the 1997 Constitution
in 1997 sarta bukuba nyinto
set out in detail the procedure
ay kolu be itandile ke landi melu mutarambulo luti
for the removal of superior court judges.
ni be kitindirla nyaton kolu bondila kiti bunda santon koto.
The judge may only be removed
wo jojo wo wole mo kitindirla sa bondino nyamemma
from office
abondi office okono
for inability to perform his or her functions,
ning amala do kolu keno anyama menketa sartol te anyanta menu tamandila
whether arising from infirmity of body
fo asekenyinti ko sa sale ya sabo amari mantara afango sawola
or mind
wala asondomo mantara anoto
or misconduct.
wala ay kutinyari ngoke.
These are the three reasons that a superior court judge could be removed.
Nyinle mudalila sabol ti me yalon ko na kitindir bunda santon ko isila kitindiro bondino dalilo menka.
The notice is given to the Speaker of the National Assembly,
Aduni ye kalamutandiro di deputy bumbala speaker la
signed by not less than 1/3 of the voting members of the National Assembly.
ando asike kuti kaititi me yalon ko ni deputy olu be kafu nyoma yetala sidula sabati satara o sidula fulo be kafu nyoma ya sign
Put forward a motion
satara wol fanali sarto ye kangolondi
that the ability of the judge to exercise his or her functions
kaitandi ko nyinkiti ndirla pour kala do ko tamandino anyama
should be investigated.
nyanta ko kisikisilale.
The motion is adopted
Ni na tawo kangolondi
following a majority of not less than 2/3
aduni na ta kangosoto me ya lonko ni dibitol tala o sidula saboto sidula fulo nyimbe satara woluye kangodi wo kango kang.
National Assembly appoints a tribunal to investigate the allegation.
Dibite bungo sina mo tombo menu be kala do ko laluti menu bina wo ko nyin kisikisila.
Tribunal comprises of 3 individuals,
Wo menu nyanta o kisikisiro kala mo sabale nyanta tarla kono.
one of which shall hold the high judicial office.
Mens kilimbe tarle kono me ya lonka la palaso nyanta kala kitindir bunda nyaton ko palaso leti.
Proceedings are held in camera.
Aduni be o ko lukela e ka ke kullole kono.
And a judge appearing
Andu kitin jojo me ya lonko kititela lo wala finto
for the tribunal
wo molu menu nyanta ko kisikisila
has the right to be legally represented.
wala moto nyanto lempro mari yello akonyin kunna.
The tribunal presents its report to the National Assembly.
Itu wol menu ye tombon kisikisiro la ulfanalu sini la kibaro futandi dibite bungma.
If the National Assembly finds that the allegations are substantiated,
Ning dibite ulfanal nata tara ko ye tumirolu menu fanyi mari kama wol mukulleti menu nata lo
then it may by 2/3 majority
itu isaje ye dibite bungulu tala o sidula sabo menu to sidula fulo nyin
resolve that the judge be removed from office.
wol ni nata kawdi ko nyin jojo sa bondi bitu tumole me ba mari bondi no la office.
Justice Jaiteh, you agree that this is the traditional system of impeachment of judges for their removal, correct?
Justice Jaiteh be sonna manyina la ko nyina mu ado te siloti me ya lonko e kawalata nyanna kawalata no purka jojo kiti tenre la santon ko ka bondi do gora.
That is correct.
Umuto nyalti.
And you would also agree that this is the procedure you would normally find in democratic societies.
Nung ibe son na manyin na fanan ko nyinam tamandri silo de me ya lonko democracy be tamakam banko menkan nyinam silo tamandri silo de nyana bulanam silo men no.
That is correct.
As far as you know,
Itala londo do.
has this procedure ever been used?
Fanyin tamandri silo nying aketa sila la de me ya lonko ike muna fangala la ban no.
In the Gambia during the Jammeh era?
Gambia banko kanjang ya jammela jamanola.
As far as I know, it has never been used.
Ntela londo to inene man tama o silola.
And my meeting with other judges as well.
Adon nin judge dolu men kata kitindiri la dolu niolu fanal la bonyo kala moto.
Also not experienced that it has been used.
Dum fanal nene maitandi ila londito ko inene tamata o silola.
Well, I can suggest that in the First Republic, you
may
have studied legal and constitutional history of the Gambia. Honourable Jabang, have you ever heard of this provision ever being used to remove a judge? Or the removal of a judge for any reason at all during the First Republic?
Honourable Jabang nyini karo mu itelati fo itela ila londo re men soto la karandiro karango e men soto luala karola be marali folo nyi jamano la no fo inana ka jela nyi kiditendi la ka bondi nyi nyasi yo nyama ba.
To my knowledge,
mambo kalama.
We can safely say at least it has never been used in Gambia's legal history before and during the time of Yaya Jammeh.
Nsinyim fono le ko woto sone ya kono ko nana memuna fa wasilo tamandiri nyala pour ka kiti nder la bondi woni silo la Yaya Jammeh la watola.
But your paper, Justice Jaiteh, is premised on the fact that these removals were frequent. What was Jammeh using to do that?
Justice Jaiteh len kayto re ben karanteng ay tandi je ko Yaya Jammeh ka jojol kiti tendir la ke bondi silo men non nyaali me yalon ko dalina kulanu silang itela mira loto no akamu tamman atakamu sembe sifa wala ka sila jumale tanu pour que muna fangala kanyin kiti tendir la santon kolta ke bondi la palaso.
In my view,
Ndela jeroto.
The removal of judges
Ruka o kitindir la lu bondi la o palaso to.
Yaya Jammeh
was
unconstitutional,
ani banko la sarta buko mantanyola,
illegal,
manke loi silati,
null and void,
andun ku kense wala fanamu,
of no effect.
andunga man dalila soto.
And that is because
andun wala nyinti katu
the section of the constitution that he invokes
ateka constitutional la bunda men kaninga kamenka kumandi.
It's not a freestanding provision of the Constitution.
Amanke bunda loring to membe loring afaye meye barumaso to constitution okono.
Section 141,
bunda kemetanna ni kilinjango,
subsection 2,
ala fanna fulanjango,
see the paragraph C.
ala sabanjango.
The president may terminate the service of a judge. Let me read it.
President asi jojo la do ko londino kamari dahandi.
But what I want to say here is either the president did not understand the provision of the constitution. So let me read it to the public that the president may have his or her appointment terminated by the president in consultation with the Judicial Service Commission.
The president asi wo mari la do ko tano ka mari bondi do ko la ning ayatara aning alfa kafo ye nyomo yi men ya lon ko lebe do ko la kito ning kitindir sakto lu kuna banko kan e ka fo le Judicial Service Commission.
I think there is a nuance in the provision which is not reflected in the interpretation. Could you kindly, my lord, read the provision again, as it is in the Constitution, and then we have the interpretation.
So let me start. Section 141.
Bunda keme anin tanani nin kilinjango.
Subsection 2.
Ala fanna fulanjango.
Reads.
Anyinefo.
Subject to the provisions of this section.
wolu membe dending wo dinkrala o sartola
a judge of a superior court,
kitindirla membe kiti bunda santon koto
paragraph C,
wala sapa sabanjangoto
may have his or her appointment terminated
sala do ko nyin tano kada handi do ko la ning
by the president
president siokeno ning ayatara
in
ko men be kito ning kitindir sarto kunna banko kan e ka fole judicial service commission.
So in my view,
Oton tela jeroto
it is either the president did not understand this provision,
wala nyindiko president mo wo dinkira nya malo nga mafahamu
or the attorney generals who were his legal advisors
wala attorney general
did not understand,
wala mafahamu
advised him wrongly,
wala ya moro diala melni silo manta
or he was just violating the constitution deliberately.
wala be constitutional la kangole tinya kan adiyanye wo kan.
And the reason for this
Adun dalilo membe okoma
is that section 141 subsection 2
wala bunda keme bunda tanani nin kilinjango la fanna fulanjango
is subjected to the provisions of section 141.
ufanambe dendi wosar tole bala menketa bunda keme bunda tanani nin kilinjango ti.
So subsection 2 is subservient
Ala bunda fulanjango woto ufanambe dendi kulela
under the control
me yalon ka be melna mara loko
direction of section 141.
menketa bunda keme bunda tanani nin kilinjango la chodi bunda
Subsection 2 cannot be used without applying the other provisions in subsection 1 in section 141.
ite o bunda tamandino la afaye nin ayatara amantara dendin sartolu la men ya lonko wolle be o bunda keme bunda tanani nin kilinjango nyin kono.
So the application of subsection 2
Itu o bunda flanjango la o fanna flanjango ka o tamandi
is condition or contingent
wo mukulet me ya lonko abelori nyame ma
on the application of subsection 5 of section 141.
woto abet denna bunda lulunjango la fanna lulunjango me ya lon bi o fanambe bunda keme bunda tanani men fring wala munyintiko.
That section must be before the president can
Barintel ngamen sotonum
is that the president will just invoke the section
bari president ka wuli le drong ay fanna nyin commandi
without invoking paragraph 5 subsection 5 of subsection 141 of the constitution.
ate ka wuli le drong ka kan taman isatara mawo fanna lulunjango la sarto of membe dending bunda keme bunda tanani nin
nyido yo kanna so nyi ngo be firinde men wala nyi digo bayro nyi nga sababu nyi nga be bola jojo nyi fango la karola.
Do you agree with that?
For isonta wala.
Yeah. I agree to that. That's correct.
Isonta wala atilintale.
Another interpretation
Rindiro do fana
is that
wala
since it is the president that terminates,
malamena president nyi nga teleka kunduro ke do kola.
The president can initiate it.
But the president fanansa and ko nyi nyata ko yano.
And that is the way it was being interpreted by the Jammeh government.
Nung jammela maralo wato la itol kafirin ni wala nyama.
So what you have
Oto ite mensoro
is two provisions. A provision that could be interpreted as resignation.
fanna fulete wala soroja wala mi follow mi wala nyida mari fa ye daha faye.
Because if the judge would instigate his removal,
Kadu ninga tara jojo nyim fa atele sababu tala bondiro nyinna.
it would have to be through by way of resignation.
Ora be kala ni nyata mi ko rawata fa wala be daha la fa.
And then you have another interpretation, which is the president can't actually terminate.
Ina na firi indir do fanan soro wala nyindi ko fulanja wala nyindi president nyim fango asina na te fango sigo jojo nyim bayno la do.
So you have two means of terminating the judge. That is by parliament and by the president.
Sila fula wala beje pour ka jojo nyim kado ko do ko nyim kundu wala katani député bu ngotala an fulanya wala president ya bay.
And this even leads to serious confusion in the constitution.
Ndu nyinara na hakili jaka so fanke kon na luwa buku ba nyim fanko le.
As to what is the right way, perhaps maybe Honourable Jabang can help us here.
Asekeno jang Honourable Jabang isinde mano jang fana.
In the 1970 Constitution,
1970 code luwa yeda hayido kola.
An impeachment by parliament. You would agree with that?
Andung wala député fana député bu fana ye bay ibeson na wala ko nyi sabol le benu.
Yes, exactly.
Abenu wala
Justice of the High Court.
Sonta Satarola meya lonko Honorable Justice member kibunda banyina ayewa meyitandi.
And assuming we invoked by the president to remove a judge of a superior court,
ko president si tukuno wo sartola pour que mo bondi meya lonko lem kiti ndirlati membe kiti bunda bato.
I believe
in the 1997 Constitution.
Tamandri silal de me yalon ko asoro na 1997 Constitution bu ko le kono.
Exactly, and rightly so.
Akita wala nyama andu atilin tanyu bo nyama fana.
I think with the aim of putting the judiciary at the mercy of the executive.
Muntanga je ko tumo na kitindu bunda ya chika leka amumeo be chika kadung kun banku nyato tonko la sarto ka adi banku nyato nkola.
And this, it appears, evinces a legislative intention to tip the balance in the separation of powers in favor of the executive. By creating a new means of removal of judges with the sole caveat of consultation. And like you have rightly pointed out, consultation does not mean you have to accept the advice of the person or institution consulted. And whether it is constitutional or unconstitutional, depending on how the constitution is interpreted. And we all agree that this is not normal in a society of powers. Is
for a luanda
in a democratic society where separation of powers is given prominence as in this constitution.
That is correct.
Andu wasarto fanga amunta aka kitindir bunda fanga koto domole ke kadumi koto
security of tenure.
Andu fanang ila kanto ni tankada ka usabatin.
I believe as a whole, statute must be read as a whole.
Andu la tala ko to ning sarto ni ba bondila wala ka banke anyanta kala kuka furu nyomole timenselo.
As I said, there are three reasons: misconduct, infirmity of the body or the mind.
Unga funu nyamen ku sabale kasa amari kuja wala ke kukurungo wala amato la meya alamfuni.
Unfortunately, this particular provision is not grounded on any reason.
And that
is the scary nature of the beast that is created. It just says a judge may have his or her appointment terminated by the president in consultation with the judicial service. So if this is read out independently from the other provisions which you say should bridle this particular provision, then this is a very scary creation. Honourable Jabang, what do you think about it?
Exactly. That is rightly so. But I think care must be taken to interpret it independently, as you've mentioned.
As my
Lord rightly stated,
na alfaya funu nyamin.
The law must be read together as a whole.
Luanyin ka karang ka ke bunda lorin kilimuti wala nyanda.
In order to make a complete sense out of it,
Uruka hakili nyima mem kusane nguti purka wasotoje. Na demokrasi sikanta.
so if you start reading the provision,
Bari niyo sarto karang damuda.
it says subject to the provisions of this section.
Betar la dendi bunda karila sartolla.
A judge of a superior
Tindirla me yalon ka be kiti bunda santon kote Omari president sala do ko kuntuno le ka dandi.
So the question that begs for an answer is, what are the formalities provided under section 141 under which a judge
Koto mune mutarambulo luti minu be bunda keme bunda tanani nin kilinja onyin koto
So
suru president si nyindo kula bayno ala do koto nyamem.
Your worship, you have raised a very important point.
Yefana kumabale we sikandija.
And it is akin to the point raised by Honourable Justice Jaiteh.
No bebe sujirin Honourable Justice Jaiteh afana efana me se wulindi jante.
That you cannot read paragraph C as a standalone provision.
Yes.
O ite sapa sabanya onyi ita karandino la kafoko umfanna de me alon ko abeloring afayen.
But you see, paragraph C creates its own mechanism.
Ya jawaf o sapa sabanya onyi afansung tamandri silo ayola londe afaye.
So a literal interpretation
Woto ni be free na
would suggest that you don't look for another procedure because the procedure is already inbuilt in paragraph C.
Be tandi le jago ra manja pour yeta fan yebi burfula nyaw bibe katum burfula saba nyaw nyi atya fan senende.
But all this discussion
Bar nyin ka chalu be kono
goes to show that there was a deliberate intention
nyi tandi je ko we te taunte ya bara balle be kerin
to give more powers to the president
sembota
constitution,
be ya bondi nyin constitution bugole kono
which you would not find in a normal democracy.
anu wo mutamandiri bulal tamandiri silol de me yalon ko democracy be tamakan dawda e buka bara tamandiri silal sifa bulal sifa le bo jewro.
And may I just take the liberty to inform that I did my LLM.
Mbal kalam da nyina ko mfanangan LMTC ngakele pour safero.
As at the time I was writing
Wato men be safero kela.
my first draft of the thesis, this provision was not in the constitution.
Safero folo nyi waro men thesis kela nyi luala bunda nyi be men fo kante ate buko nyi konon.
So this was a late addition to the constitution
Mukam danne de me alon ko narana ke ko nato do mandine.
aimed at empowering the president, advantage of the judiciary.
Isaje nyi kamalo ko kiti bundar nyi na ila de rokan.
But I read this
Ngani karang
as the beginning of the creation of a dictatorship.
kaje ko be sembela maralo nyi damuta dula folo nyi na wato
Because the people would rely, the people's last hope is the judiciary, and the judiciary was rendered impotent in the presence of the executive. What do you think, your worship?
Molla jigida laba dingira menti wala kiti bunda and wo kiti bunda fan kilingol fanani wol fanan keta mollet me yalon ko ibe mollel ko me yalon ko ka fo executive yo wasibite mun sabe me follower.
I will have to align with your statement in total.
Ila kuma kama nyi
So Justice Jaiteh, the judiciary had a preferred interpretation. That is the one you gave.
Judiciary memu kiti bunda di toli la kanna sor la nyasilo la soro me yalon ko itoli kiti bunda nyi nyana tamara o silo la andu ite wala karande.
It is quite clear that Jammeh did not support that interpretation.
Nunga seneyata la ko Jammeh atawo kanna sor nya bunda nyi luwa ite ya kanna sor nya men ya Jammeh amo fasa.
Tell us how Jammeh applied this provision.
silang afonye bangata ya jamme ate munafan nyimbunda la luala nyimbunda do la nyimbunda la nyadi le.
Yeah, I believe that the Jammeh would just dismiss or terminate the service of a judge.
Man la nyim fon ko ya Jammeh be wulla dron jojo wala kitindiri la ka wala do ko londi lo nya ka bay la do ko to nya.
In the consultation,
that
is on the paragraph C. In my view, has never been applied. Because as a judicial officer, if an allegation is made against you, it cannot just be oral or verbal. It must be written. And the judge must be given the opportunity to react.
And doing
But the judicial service commission will do that to react to that allegation.
Kitindir bunda la alfalu menu be kiti kunyalu kunna Judicial Service Commission
And the Judicial Service Commission will make it decided or not.
So alfa ka fo wolle bina kawlondi la ka fo ko ye tumiro mem fo nyimma. President mantra kitindir bunda la.
It is the Chief Justice.
Chief Justice Lem.
And he is the chair of the Judicial Service Commission.
And that
there has to be audi alterem partem.
Citizens.
When the
citizen has a problem with the state,
it runs
to the judiciary. When citizens, two citizens have a problem, come to the judiciary. So that institution must be, the judicial officers cannot just be removed easily like how we have it in the constitution. How it was done.
In a sense, you are saying weakened our democracy and strengthened a dictatorship.
That
is correct.
And tell us how it was applied in real life and the impact it had on the judiciary. I asked this question noting the point you raised in your paper, saying when you said in paragraph 4 that by subjecting it to the removal of a democratically elected National Assembly and establishing a higher threshold of action by that body, it remains vulnerable to politicization. And then you went on to say that in practice, this concern becomes more apparent in view of the strong majority of the ruling party. You were there talking about the other provisions, their impact.
Yes.
But perhaps before then, tell us the impact of paragraph C, 141 paragraph 141(2)C, and then we would come back to the general import of the of 141 in general. Tell us about the net effect of 141(2)C as interpreted by Jammeh and the executive, pretty much.
Well, the impact of section 141(2)C.
Section 141 wala bunda keme bunda tanan ninkilin la sapa fulan la bunda saban nying,
that there was no due process.
Nyina itandi ko tumo kulorin te kerinu,
and judges were arbitrarily terminated
without
giving any reason as to why it also gives the executive the power
and
control over the executive, over the judiciary, over the judiciary. And also the insecurity of tenure. And it also distract competent people to be attracted. So at the end, in the judges or individuals or lawyers who are competent enough fit and proper persons are not attracted to the bench because they could easily be terminated for no reason, and that could be humiliating, embarrassing, and demoralizing as well. So it was literally, this provision literally was to kill the judiciary. Render it as a tool of oppression. You will end up having judges and magistrates who will be compromised and compliant.
Perhaps let's not go back to the other provisions of 141, even though they have problems. As you suggested, it's a normal provision you would have in a democracy. And it is more miles better than the dictatorial provision you would have under 141(2)(c).
Ajam fata ba ke nyole kam be men sota la 141(c) be men sota yalan ko sembela maralo la ngoti.
Tell us one classic example
Misal kilindin na bang
where 141(2)(c) was used for the benefit of the executive. I am looking specifically on your mention, discussion on paragraph 5 of your page.
damen de yalan ko ye muna fam bunda ke me bunda tan nan kilinga la fanna sabanjango nyinto ke muna fanga la puruka executive wala miya jamina la bala mo ke sembentia.
Well, the section, as I said, section 149, 141, 1 to 4.
Kunga funa nyame bunda keme bunda tanna nin kilinjango kabwa fulo la kata nani njawti
4 to 9.
abo ala bunda nani njawon kata la bunda kolonton njango kan
That there's a procedure of removing a judge
wolem ko la nyati pour ka jojo bondi ala palasoto
under subscrutiny.
ando fanam betar la dalila le kamme yalon ka be kal député bu la crossiro le kandi.
That provision has never been applied.
Inene man tama o silola.
But there is a danger in that provision as well.
Bari kolea ko be o sarto fanan konole.
The National Assemblies of the previous administration
Député bu fololu men bijam marali fololu la wuce o kono
were rubber stamped or were subservient.
wala munta dron danko dron député wala moyete bari bitung katara a koñim fango dalilo kan
To the whims and caprices of the executive.
munta wol katanya le koto.
So subjecting the approval by an elected National Assembly
Ka kolu la bunda la me yalon ko le kata député bunti quartier fayta men ye
either could be politicized.
isa keno politiko siloti
There could be a majority in the National Assembly
anda sikeno itel bari ka foko wari député
be removed.
isa kitindi la nyum bondino wala place to tarin ke fa.
So the whole process
Bitung
before the National Assembly
koñim fango be la nya député bu nyatilim la
politicizing the removal of judges.
pour ka jojolu la place ta ke bondi la place to pour ka ke politiko siloti.
However,
Aro nyawnyandi
the procedure has never been used
asilo nyin in le memuna fangala
because it's cumbersome
kato akonyi ku jamale bakolo
and the executive or the president, was just using it, just giving orders to have the judge removed.
abunda president ne wotumo wala kundon ko nyate ka kangole di doron pour yo jojo wala o kitindir la ya bondi la place to
Invoking section 141 subsection 2 paragraph C.
amonta tela bu kanindro katalarin bunda keme bunda tanan nin kilinjang la sapa fulanjang ala sapa fulanjang la kan aningala bunda naninjang.
Yes. So judges, example of judges being removed, there are a lot of judges whose service were terminated.
Amonta sniaji be mansalim kamara ye joju jamal le la place lu bondi bu sila janke fonyondi
Supreme Court panel
Supreme Court walem kiti bunda balaw alfasi ringlu
involving Chief Justice himself,
tabula Chief Justice Fangola,
Justice Chauhan,
Justice Chauhan,
Justice Jibujane, Honourable Justice Jibujane,
Honorable Justice Jibujane,
Justice Sok,
Justice Sok,
and other judges who sat at
anin
the panel
George Kotangulu, menu sita kunna.
were literally removed.
Yolu be bondi la palaso to wala nyama kutarengu kan.
There was no reason. I mean, the Supreme Court became, there was the Supreme Court became vacant.
Anu wala na Supreme Court kiti bunda ba nyina ta kolonya.
What must have precipitated that?
Manena na sababu wala
Because they gave a decision.
Atu ye kangole londi.
In which case?
In the case of the
Titi
state
Juma kono.
and Lantombon Tamba,
Men keta lantombon tamba la kito nyin konoti.
when they reviewed it and decided, to reduce the sentences,
Iri ya yube na tanyin kangota purka ya soro yiriko men na purka utala.
acquit discharge Sajo Fofana.
Ina ta Sajo Fofana la kito buruka kia bula ya tata.
my view, the president thought that was dangerous.
Ndela jero do president ya merako muma siba quality nu.
So in effect, the president, Yahya Jammeh, did not like the decision of the Supreme Court reducing Langtombong Tamba's sentence and acquitting Sadio Fofana.
Munta president Yahya Jammeh malla fi Supreme Court be munna kiti bunda santon koti wole kango menta pour ka Langtombong Tamba sorondiro men ya kala pour ka wala sanjo nyin ka tala anin Sadio Fofana ko ta ka bula ka je ko luwa mamuta no kiti yo fana ya bulale malla fi wala.
He didn't give this as a reason.
Rata mawdi ka wolem daliloti de.
But he reacted to this decision by the Supreme Court.
Simfanyin tawi ko kangol la mealon ko kiti bunda santon ko nyinga kango menta simfata wal.
Yeah, that is correct, and fired the whole panel. And there was no Supreme Court.
Supreme Court
As on the basis of the information you received, was there any consultation as required by the provision that he relied on?
For nyomoyo soton talaban ko ite bunda me yalon ko ite ko ajujita no bunda nyinela luwa bu ko nyinkono.
As far as you know.
There was no consultation as far as I know, and the information I received from other judges as well, there was no consultation.
It
therefore means, even if one were to accept that Section 142C can be a stand-alone provision,
section 142C
he violated the requirements of that section.
That is correct.
So it means that even if he could rely on 142C, his action was unconstitutional.
2C.
That is correct.
Was his decision effective? In view of the blatant unconstitutionality of his action.
Well, the former president Jammeh was the alpha and the omega.
President Jammeh.
Break that down for us to understand.
He was everything almost. What he said, is decreed.
I meant for drone amunda wala county member.
That is just sort of
because if you look at it, it is the panel of this is the Supreme Court, the apex court, and the Chief Justice himself.
And tembo olem kolu timeni alon ko tilom kitibunda la kolu kunton court katabula Chief Justice Fawla.
What it means in plain terms is that the president arrogated to himself the power to remove entirely the top echelon of an equal branch of government.
Amunda president wa sila leta me ya lonko ay sembota dia fanga ka ding bunda janjam me ya lonko bunda la me ya lonko tolum nyaton kolti surdu ka ni dubes luala karola sembol be fara fet talari nyoy tema nyamen ka bunda nyaton kolta ke bon date wala.
I'm not sure that is the exact interpretation.
Amunta
But what I am saying is,
president o nyin dunota fankan mansa kunda bunda membe loringa faye kawola o nyaton kolu mume
equal branch of government. That is the crux of the matter, and equal to the executive.
Anu nyimo bundal de me yalon ko ma fay su bundal de mansa kunda do ko la karola dabe mansa kunda bundal ko me yalon ko e belori fay.
That is correct, and that was the beginning of a very bad start at the
Omutonya
beginning of his own downfall.
omutonya atuntela jeroto
This
court mu kiti bunda kuma baleti is the loringoti
and we were,
ngantilim president carte fayole la banko ka
there was a need to have
Supreme Court la bunda saharim bunda timari ngo nyanta tarla lori
Supreme Court.
adu solo be tarla nyinale safer la no be sutola le menu be ila kalamirolu safela kaki Supreme Court
to challenge the decisions.
pour ka kanka lo kangolu dolu nyato pour ka kangolu dolu ke soso
The firing of the apex court, this constitutional court, in 2015.
2015 pour ka kiti bunda alifalu mumewlu ke be bondi o palasoto ki amunta do ko bunda mumewla kunton kolu kawlu be bondi
Few months before the National Assembly, before the presidential elections.
fula jannin carte fayo be sila
was crazy. And no sane president will do that.
omu kuleti me yala nin hakilin tayale fon muliyata omu kuleti me yalon ko ku kebalole moti mo manyana
Without having a replacement also.
andu manna dolu ki yemen si sayo dol la place oto
Perhaps maybe he was
If the election decision was the reverse, it may have been a genius decision by him.
Ninga tra ukarde fa nyingala result zo nyingana na findi ni nyado nyaman abe kala nun kudol te me yalon ko be gola la karol.
But poetic justice, he was hoisted by his own petard.
Dafa ngola baro nyinga dafa onara na bulala o baro nying kona menke.
absolutely correct.
amunda wala mtu anyati
So that is the danger. That is what he thought. He thought, it would be the other way around, but he ends to. That was the beginning of his fall.
atela miroto atela mira wala mkukendo ti atefe bari bitu ngole na atake atefon boyoda mutablati
Justice Jaiteh, proceed with the rest of your present.
Justice Jaiteh is intended no ila
yes.
Point of observation. I just want to bring to your attention that in a serious democracy,
lafta hakilo bulandila nyimfana nako democracy sobe obedaoda
it would have been caught under section 67 of the Constitution.
nyanda tarla bunda taworo ni worowla njaw koto na bankola constitution okono
It could lead to his impeachment.
me yalon ka sike sababoti pour atefango ye akito sa ulinde atefango kama
Whose impeachment?
The president,
pour president fango la bayro
for willful violation of the provisions of the Constitution.
pour nyin kamala ay tawnte yale ka constitution wala kanglu burka ka balang itamandila
I underline in a serious democracy.
Exactly.
ngaje nunela de ko in democracy sobe obedamen ngaw nunele.
Thank you very much for that observation.
Baraba kelo krosi.
But you see, Section 67 has never been invoked in this country.
Bare ite bunda men for men kera taworo luluti amang
taworo ni
woro la nana me muna fanga la nyum bangkong kanja.
In fact, when matters came to a head, what was done was to extend the life of Parliament, which automatically extended the life of Jammeh's presidency in the face of a resounding and clear declaration of the sovereign will of the Gambian people that Jammeh's rule must end now. His rule was extended by extending the life of Parliament, tantamounting to almost treason, because it's an overturning of the sovereign will of the Gambian people.
bari muna na take wo dalili go kolu kono amunta Gambia banko dingolu yenganiyo me yitandi ila fita menna yole fintindi karte keso la karola bari munena ke ina ta ite lamaralo wuce wala fa ya tala nyaton kaya wuce wala fa me ya lon ko wol bem kuleti menu ni banko jamfa jawole tata nyola tubabul ka ko me trisin o mu kuleti me ya lon ko itel nata lo wole kam me ya lon ko am ku ke baluta buka ka manyan kala fanan
but that is a conversation for another day. I'll allow Justice Jaiteh to proceed with his presentation.
Thank you, Council. So while the removal process set out in section 141, paragraph section 4 to 9,
bunda nan kilinjango ala sabanjango la bunda nani njango
of the 1997 Constitution,
member 1997 Constitution okono
offers some safeguards for judicial independence.
we lula dolu chodi le pour kitide itande ko député bu me ya lonko karte fayta député lu men ye tilimu ni Sénégal kono satara wolle fonglu fanal bina kango di la pour ko bundu wolle nyanta ku keta saharu lu londila me ya lonko député le be o kango di la.
However, it leads to politicization.
Me ya lonko politiko kango sidunga ko
Concern becomes more apparent in view of the strong majority of the ruling party in the National Assembly.
ni nata ke kantime ya lonka findita mo jama me lonko politiko timfatari ngole mo woti
Remove a judge.
ruka kitindira bay ala palasu bari president la sembo
Just concerned to
balamu
soo bëggee jot xaalis bàyyeekoo UK Europe USA Canada Switzerland ak àddina wërngal képp Supersonix Money Transfer ñu ngi ci ànd ak yéen ak yónneekaay xaalis bu gën a màgg ci Gambia mën nga jot xaalis fépp fi nga ne bàyyeekoo kaatong ba koy na te doo ci am benn jafe-jafe waaw mën nga jot xaalis bàyyeekoo ci sa ay mbokka ak am di jàmma nekk ci UK Europe US Canada Switzerland ak àddina wërngal képp ak suñu yónneekaay xaalis bu màgg bi nga xam ne dafa wóor gaaw te noppale fii ci biir Gambia Supersonix Money Transfer ñu ngi ci ñetti fukk ak ñeent dëkk ci biir Afrika ngir jox leen melowaay yu gën ci jotum xaalis bi nga xam ne kenn du ko laam-laamee saytu leen ñu ci Google Play Store wala App Store ngir mun a bindu ci suñ app bii di Supersonix Money Transfer app ndax ngeen mun a bànneexu ci suñ money transfer services yi ay mbégte rek la ak Supersonix